Welcome to Forum 360 on Fusion, your PBS channel and your Rubber City radio stations. We're co-sponsored by the Shaw Jewish Community Center. This is Leslie Ungar, your host today. Most people remember where they were when a momentous occasion took place. First man on the moon, when JFK was shot. For decades to come, this spring, known by some as the Liberal Spring, may be talked about, studied, challenged, more than any singular event in our history. In what seems a very short time, the U.S. Supreme Court handed down two landmark decisions, one on same-sex marriage and one on what has become known as Obamacare. Either or both of these decisions are divisive and consuming. These cases question and challenge what some people see as their way of life. Is a marriage between a man and a woman or two people who love each other? Is health care a right or a privilege? A bigger issue is the role of the Supreme Court in our government and in our lives. We have with us today two attorneys schooled in constitutional law to help guide us through the legal side and ramifications of a Supreme Court decision, and in particular, these two Supreme Court decisions. Thank you to our guests today, David Kern, Akron Office Partner-in-Charge, and John Hill, Chair of the Buckingham Litigation Practice Group. Both of our guests are listed in the Best Lawyers in America and Ohio's Super Lawyers. Thank you for joining us today.
Thank you.
Sure.
We may remember from junior high or high school that there are three separate branches of government: the executive branch, the Congress, the court. But tell us, from a legal standpoint, how permanent is any decision that comes from the Supreme Court?
Sure. It's probably of the three the most permanent. And the two cases that we just you introduced and we've seen in the past few weeks are great examples of that. The Supreme Court has the final say on what our Constitution does or does not allow or permit or provide. And the Supreme Court has the final say on a statute or a written law from Congress. If its words are subject to interpretation or if the words of a law are ambiguous, the Supreme Court is the body who decides what it means and what that means for the rest of us. Once the Supreme Court has ruled, your options for avoiding that ruling are very, very slim.
If we go back to 1776 or before 1776, if you could be in the room with the fathers of the Constitution, so it seems that what you're saying is they gave the final power to the judicial branch. They didn't give it to Congress and say, your word's the last word. They gave it to the judicial branch. You know, as attorneys, any thoughts on their thinking as to why they gave this finality to the judicial branch? When they had a choice, they could have given it to the executive branch, like in a monarchy. They could have given it to Congress. Why'd they give it to the judicial branch?
Well, frankly, some people would argue with you about whether the Supreme Court actually has that final power
or they took
or not,
it.
or whether the legislature ought to or not. And we see battles amongst the three branches of government about that all the time. I think, though, that when they set up the checks and balances amongst the three branches, there are some reasons. First of all, the way it was set up was that the Supreme Court justices are appointed for life. They don't have to run for re-election. So they're not responsible to have to answer to the angry mob and get themselves reelected and make decisions on a short-term basis, which is something we see as a problem with both presidents and legislators. That's the first one that comes to mind, probably the most important one to me.
And you also see that playing out in the opinions and the dissents and the majority opinions, where they have different philosophical views on how the Constitution should be interpreted.
There's an article that's going around that's fairly recent, but Bill Clinton owns up to mistakes he made in his administration, and in one of them he comes out and says, I did it because I didn't think I would be elected if I didn't. So kind of what you're saying is not answerable to an election, has an advantage in some ways, but I imagine that there are people out there that say that they're not responsive to the people. So how do you answer when, because they don't have to run for re-election? Is that in any way a bad thing?
Well, those are all interesting questions, which are all getting tossed around in the news and amongst politicians right now. If we first focus on what our system is, there is technically a way you can get around a Supreme Court decision if you don't like it, and it's basically to amend the Constitution. That process is very difficult and hasn't been done for decades and isn't really a true practical solution. Interestingly enough, because of what we're talking about, there's now a big discussion amongst constitutional law scholars, politicians, anybody who's interested in government about whether we ought to amend the Constitution or enact a law that eliminates the lifetime service for United States Supreme Court justices. In the last couple of weeks, I've seen a couple of really interesting articles about that very topic. Again, I think that's unlikely to happen, but one of the things that's really beautiful about these two cases is they've just opened up so many doors and things to talk about for people who are interested in the law and interested in government.
So let me ask each one of you your answer to this question. In January of 2017, one thing we know for sure is that there will be a new president in the White House. Can a president change in any way a Supreme Court decision?
Can a president change a United States Supreme Court decision?
Yes. So if someone is going to be running for office and says, if I'm president, I will change this decision, can they?
No, they can't. That's a oversimplification, but the short answer is no. The only way to change, for example, the same-sex marriage ruling, the only way to change that now would be to have a constitutional amendment. Now, there are things that a president and the legislature can do to kind of chip away at the ruling or bite around its edges to lessen its impact, and I think that's what we're going to see both on the Obamacare and the same-sex marriage thing. You're not going to be able to change that ruling. The best you can do in the other two branches of government, if you're not going to amend the Constitution, is to enact some laws to limit its force or the things that you don't like about it. Would you agree with that?
I would agree with that facially, but what could happen is that you could appoint Supreme Court justices who would take up a similar type case, who would then overrule the case based on its facts. But it would be a different factual underpinning, but it could have broad implications. So I think that's the one thing that people need to be mindful of when they vote for president. That's something that can occur.
So the presidential primary season is underway. Yahoo! Self-proclaimed candidates are already saying that if they were president, they would repeal one or the other. They would repeal, they'd replace justices. States are saying that they won't honor. So let's look at each one of these promises. We hear appeal all the time. Can a Supreme Court decision be appealed, and to whom would it be appealed?
No, it's the final word on the law.
Okay. So that's clarity. When I talk, as a communication coach, when I talk about clarity, that sounds like clarity to me.
There's no higher court to appeal to.
Can a Supreme Court decision be repealed?
The short answer is no, other than through amending the Constitution.
Which brings us to the Dred Scott decision was changed by the 13th Amendment. You touched on that. What are realistic chances as candidates, make promises as they're, sometimes do during campaign time? What are the realistic chances that either of these decisions can be changed with a constitutional amendment?
From my view, very slim. The process, there are two ways that you can amend the Constitution. You can get the House and the Senate, the United States House and the United States Senate, to pass a two-thirds vote proposing an amendment. That's step one, which in our day and age and on these topics would be
get them to agree on anything.
Quite difficult to do.
Let's say two-thirds.
Two-thirds.
Right.
And then after you would do that, you would have to submit this proposed constitutional amendment to all of the states and get 3/4 of the state legislators to ratify the constitutional amendment. That process
It's another impediment.
in today's day and age, and on these issues where the public is so evenly divided anyways, it is, I hate to keep using the same word, it's theoretical only, it's hypothetical only. But if they wanted to do that, I mean, we have a Congress who's tried how many times to repeal Obamacare now unsuccessfully.
Every week.
Yeah,
Yes.
they may keep trying to do it.
I tried to look up a number, and I can't even find an exact number for how many times
It's
they've
more than
tried.
50. It's
Yeah.
more than 50 different bills have been proposed to try to repeal Obamacare, I believe.
Now, some states are taking a different path and saying that they will not honor gay marriage. Can a state not abide by a Supreme Court decision? What are the consequences? It doesn't seem like it worked out well, during the Civil War when states decided they didn't want to honor it. It didn't seem like it worked out well, but legally, can they not honor either something with Obamacare or with same-sex marriage?
They can't honor it if the government is going to do its job. That's a part of the 14th Amendment. It says that you aren't just a member of the state that you live in, a citizen of the state you live in, you're a citizen of the United States of America. And you, as a state, can't do certain things that violate principles of the United States. And so if, for example, we had a court clerk who said, I'm against same-sex marriage and I'm not going to issue licenses to them. When you have state action, government state actors who are refusing to abide by federal law, the federal law is going to be enforced against them. We've seen it in the past. We've seen it when Governor Wallace didn't want to desegregate schools, and President Kennedy literally sent the National Guard in. I don't think it's going to come to that here, but the states cannot do that. An interesting question, which maybe you'll get to in a bit, Leslie, is whether private citizens can do that and what their options are.
And that's going to be interesting as we talk about housing, as we talk about job discrimination. I mean, really, same-sex marriage is kind of just touching upon equality. But if we take a trip down memory lane of health care, March 23rd, 2010, it signed into law. First serious constitutional challenge to Obamacare came in June of 2012. 28 states filed joint or individual lawsuits. As I said, I can't even find the exact number of how many challenges there were in Congress. So if I asked you, is Obamacare here to stay, what is the answer?
It's a tough question. It appears that the framework is now established. We're the only industrialized country that doesn't have a national health care system, and we've got the health insurers involved. So I would think that probably all the things that you need for permanence are there. That being said, if you have a Republican elected president and a Republican Congress, it could be repealed. Then you don't know what you're going to have after that. You might go back to the old system, which was, I think, untenable under the circumstances, because costs were escalating and it became a very difficult situation for employers with costs escalating the way they were for health care.
Now, let me ask you, because you're also an advisor to businesses, would you say that from what you've seen in Obamacare since 2010, has it helped employers control costs?
I think certain provisions of the law have. Yeah, I think there's more predictability in it. I think initially there was concern that there'd be spikes in the rates of insurance that were charged. I don't necessarily know if that's occurred. I saw recently that the insurers were going to be putting in for higher rates, but it all depends who you ask, how that plays out, how that shakes out.
What a surprise. Our guests today on these two landmark Supreme Court decisions are David Kern, Akron Office Partner-in-Charge at Buckingham, and John Hill, Chair of the Buckingham Litigation Practice Group. I've always wondered why it's called a practice group. Aren't you done practicing? Don't you know? Why is it called a practice group in law firms?
Practice makes perfect.
That's right.
Is that it?
No, I don't know why. That's a great question.
We probably hired some consultant.
We should
be a practice group.
Said that would be a good name.
That's a good name.
We should come up with something.
Same-sex marriage is at a different place in its journey than Obamacare. It seems like Obamacare has been tested and we've had it around a little bit longer. Same-sex marriage hasn't been contested a million times yet. What can people expect of this same-sex ruling? Will we see it challenged as we did with Obamacare, or would you say that it's here to stay? Where is same-sex marriage in its journey constitutionally?
I agree with you, Leslie. I think personally Obamacare is here to stay. There are things, because Obamacare is a statute enacted by the legislature, if the next legislature wanted to come in and try to repeal that statute and enact a new one, they could. I don't think that's likely to happen. But I think, as you said, the same-sex marriage issue and all the different doors and questions it opens up, we're just standing at the beginning and looking out over all kinds of very interesting questions. To cut to it, I'll tell you what I think is going to be the next battleground on this issue is going to be this argument about freedom of religion. I think that both politicians and private citizens who don't like same-sex marriage and don't like the holding that same-sex marriage is a fundamental constitutional right are going to take the position that it conflicts with a different constitutional right, namely their right of freedom to express their religion. And they're going to say, the classic example we're hearing is, well, if I'm a baker and someone comes and asks me to make a cake for their same-sex marriage, I'm not going to do that, and I have a constitutional right to not do that. And that's going to be, I think, the next battleground.
Okay, so Mr. Constitutional Lawyer, which side would you defend? The baker or the same-sex couple? Or let me ask, which side has more of a legal defense?
It's a very, very difficult question, Leslie, and I'm not trying to skirt the topic. I'll tell you that, if I can just give you a little bit of context. I think one of the reasons this is going to be the next battleground is because the constitutional religious rights under the First Amendment are probably the vaguest and most difficult area of constitutional law. It's probably the area of the law where the Supreme Court, of the United States Supreme Court, in my opinion, and those of a lot of commentators smarter than me, have noticed that the Supreme Court's decisions on religious freedom and expression of religion are not very consistent. It's hard to read a case and decide and predict how they're going to rule. The Second Amendment itself is almost contradictory in that it says, you'll remember, I'm paraphrasing, that Congress shall not enact laws that tend to establish religion. But by the same token, Congress shall not establish any laws that interfere with the expression of religion. Well, a lot of people have noted those two things almost don't seem to fit together. The first part of it, what they call the Establishment Clause, Congress shall not establish religion, basically has been interpreted to say, well, there are some religious beliefs that are so deeply held that they're going to override even a valid law. For example, conscientious objectors for years were allowed, even though there was a lawful draft and you had to comply with the law and show up, if you could prove that your religion made you a conscientious objector, then you were given the right to not go. And so these two competing parts of the First Amendment and how they fit together lead to really difficult questions even for constitutional lawyers. And I think there's a lot of fertile ground there in gray area, and that's where these issues go. And so I think that's why I think those who are kind of plotting what are we going to do to oppose same-sex marriage, they're going to this issue of religious freedom.
And it'll have a lot of political appeal.
Absolutely. Yep.
So I think you'll see that advance for that reason, for no other reason.
It motivates the base for the right.
So
Yep.
This may not be a fair question, but oh well, so what? When you hear a candidate on a news clip or an interview show saying something that you know as an attorney isn't true or valid or possible, like, what do you say to yourself? Do you just, how do you handle that without being frustrated on a daily basis?
There's really no filter on that.
So we're allowed our opinion even if it's wrong, right?
Correct.
Right.
And that's, I agree with David, that's the part of, that as lawyers we try to celebrate decisions like this. They get people's kind of tempers and opinions inflamed, but that's a part of the process that was set up. Somewhere right now, someone is listening to my opinions about the Constitution, some lawyer probably, and saying, that's not true. I completely disagree. And how do we know who's right? We know if and when it gets up to the Supreme Court and those particular 9 people at that particular time rule one way or another.
Right.
And interestingly enough, like with Dred Scott, it may not be that they're even right, but at that particular time.
One of the fascinating things, if you want to look closely at the same-sex marriage debate, is looking back at the Virginia versus Loving case from the United States Supreme Court, wherein the state of Virginia and others had laws that forbade interracial marriages. All of the same arguments were being made in those cases that are being made in the same-sex marriage case. And after the Loving versus Virginia versus Loving case was decided, and the Supreme Court said those laws are unconstitutional, and you can't prevent a black man from marrying a white woman or vice versa. All of the same threats and outrages were made and threatened and talked about, and then the country kind of accepted it and moved on. And now when we look back at it, you almost cringe to think of it. Mm-hmm. Will we get there about same-sex marriage? It's a matter of opinion, but probably see mine.
In the few minutes we have remaining, and in the 50 questions I have left, I'm going to ask for 1 or 2 word answers. Some say that same-sex marriage was the easy one, that the LGBT community not being protected in housing or employment is going to be more difficult. What do you see in the future with these issues in a sentence?
David?
Well, I'm assuming they're going to work their way through the courts, and I'm assuming that ultimately that they will be granted the protections that everyone else has.
Can a clerk in a county courthouse anywhere in the United States refuse to issue a marriage license today to a same-sex couple?
They can do it, but they'll face consequences.
Can a judge refuse anywhere in America to refuse to marry a same-sex couple?
Same answer.
And can a clergy refuse to marry a same-sex couple?
Now, that's a
more
much
tricky,
tougher question. I think the answer to that is yes. I think clergy can. But that's going to be one of these issues, I think, that just as the same-sex marriage opponents are fighting it, I think that the gay, lesbian community are going to keep pushing. They want more of these rights, and I think that's going to be a real battleground.
Now, speaking of rights, from a legal standpoint, what are some benefits for a spouse in a same-sex marriage that are legal benefits? How are they protected differently than they would have been in a civil union?
All federal benefits were protected, okay? But the rights for adoption, so if you're an adoptive parent, if something was to happen under the old rule, if there was an adoptive parent, then that parent died, the custody was not certain. The federal law had moved way before this case.
So there are legal protections that we don't really think about, we as mere mortals don't really think about in
Correct.
The protection of marriage.
Correct.
The law hasn't progressed to the next step, which the gay lesbian community wants, which is to identify sexual orientation as a protected class, just like race, religion, gender, etc. That we aren't there yet. That's something that Congress or the Supreme Court might do in the future. So some of these areas are still left to be worked through.
Or it might start in the states.
Could start in the states.
Yeah.
What next? What do you see the Supreme Court ruling on in the next few years that will greatly impact our lives? Is there?
You need a crystal ball for that.
Yeah.
And your crystal ball?
Because they decide what cases they're going to take.
I'm a court watcher more so because of what I do, and the first 2 that come to mind, one are all of the religious rights issues, and the second one, I think we're going to have another go at abortion rights.
Really?
Yep, I do.
Now, do you think there'll be another go at these super PACs? Do you think that, will that get dealt with at any level? Will that get dealt with in Congress? Will that get dealt with at the Supreme Court? Are we going to see a revisiting with the super PACs, or are they here to stay?
Yeah, I wish there was a better answer, but I think if it gets revisited, that they're going to broaden. I don't see this court pulling back on those issues. I think we're going to see more corporate money in elections and those kind of things, if anything.
Right, and it's ironic because I think that's part of what the Constitution was designed to protect against, is the ability for a few people to really control the democracy and the discourse, and that's kind of what you see in the super PACs.
Some of the justices, in writing separately in the other earlier political fundraising cases, have already hinted that they think it should go further. So I think we're going to have a revisiting of that issue, and it's with the court as it's presently constituted, it's going to be more corporate money and not less.
Yeah.
Wow.
Yep.
Now, when I look at the justices, I'm a big fan of Ivy League education. I think it's wonderful. I do not have an Ivy League education, but I think it's wonderful. In 1 or 2 words, can you give me your insight into whether or not you think it's a good thing that every justice went to Harvard or Yale?
I think in in the same-sex marriage case, the justices point that out, that, look, you've got a small group of 9 people, all of whom went to Ivy Leagues, most of whom are from the Northeast, making these decisions. So I think as a practical matter, you are where you are, but the wisdom of that I'm not so certain of.
I think more Case Western University School of Law graduates should be on.
Throughout our history, the Supreme Court has established a system of checks and balances. The power of the Supreme Court within the federal government we feel every day. For today's guests, David Kern and John Hill, thank you for helping us understand these landmark decisions. For a country that, like it or not, needs to embrace change, we thank you. This is Leslie Ungar. Thank you for joining us today on Forum 360.
Forum 360 is brought to you with support from Electric Impulse Communications, Kim and Harvey Nelson, Rubber City Radio Group, Akronist.com, AkronBuzz.com, Forum 360 supporters, and the Shaw Jewish Community Center of Akron.